Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Wesley Hottot, Senior Attorney at the Institute for Justice. We will discuss the pending Supreme Court case Timbs v. Indiana, in which Hottot represents the petitioner, Mr. Tyson Timbs. So welcome to the program, Wesley.
Oh, thank you for having me.
So it's great pleasure to talk to you. It's been a little while. We've known each other for a long time now. But I was wondering if you could say a little bit something about yourself, your background, and sort of how your career took you to the point where you became a Supreme Court litigator of all things.
Well, you're the perfect foil for this story because after going to my parents as a dirtball bike messenger in Seattle and asking them what I should do, I was encouraged to go to law school, which I sort of accepted with a shrug. I mean, the other dimension of this, of course, is my long-running competition with my wife, Annie, who herself is a brilliant lawyer and went to law school around the same time. But I found myself at the University of Washington, and in my first summer, wanting to work for a specific judge of the Washington Supreme Court, Richard Sanders, who was known as a libertarian. My primary affinity to him was that I saw him dissenting consistently in criminal cases, and that encouraged me to kind of want to be on his team. And when I walk into the interview, I'm surprised to see somebody I know. It's Brian Fry saying in his jovial manner, "Wesley, I guess this is off to a good start for you." I had no idea that you were there, but that landed me my first gig as an extern to the chambers while you were a clerk there. And then you and Justice Sanders encouraged me to work with Bill Maurer and Michael Bendis, at the time, the two attorneys in IJ's Seattle office, where I now work.
Fantastic. And you've done quite a bit of litigating before you took on this particular case. I was wondering if you could just kind of give us some highlights of sort of like how your career has developed.
Well, I'm very fortunate to work at a place where we're encouraged to be entrepreneurial and seek out cases that we see as good vehicles to change the law for the better and make them happen. I mean, all throughout, I get emails and calls from our management saying, like, what do you need to win this case? And that puts a lot of responsibility in a young lawyer's hands early. And I think a lot of us recognize that in an era where cases are primarily decided based on briefs, there's not a lot of opportunity for courtroom time, even for really talented young advocates. IJ is a special place in that regard. You can be arguing your first motion within your first months of being an attorney there. It's part luck. It's part being prepared and in the right place at the right time. For me, I've always kind of done my own thing. It's been great. Like, I just pursue the cases that I'm excited about, and they support me in doing that. My first big win was in my first big case, a challenge to Texas's cosmetology regulations as applied to the practice of eyebrow threading. If you're not familiar with it, it's a South Asian hair removal technique that involves just sewing thread. And the state insisted that threaders needed 750 hours of training in conventional cosmetology techniques. That is to say, not a minute spent on threading. They didn't test threading on their examination. You essentially had to learn how to do an old school weave to be able to do something that the state wasn't actually familiar with and wasn't teaching anybody. In the end, we lost in the trial court in challenging that law based on the Texas Constitution's protections for economic liberty. We lost in the Court of Appeals, and then we won in the Texas Supreme Court by a vote of 5-4. The court held that you can't make someone do something useless to their job in order to continue doing what they're doing. We emphasize that perhaps if the state was actually teaching a reasonable amount of threading and there was, less of a burden, that might have come out differently. But 5 judges of that court agreed with us that the Texas Constitution protects a person's right to go into business more so than the federal Constitution does. And the Timbs case is kind of a similar approach, right? Like it's focused on the balance between state and federal power. What are the rights of the individual vis-a-vis government power? I like to think of my job as like, where is the line? Like I know that I'm doing something right if the court at whatever level is concerned about where it's drawing a line, because that's what we're trying to do.
Yeah. Yeah. So maybe you could say a little something about the background of the Timbs case, like, who is Tyson Timbs? What happened to him? And sort of what was the litigation like before you got involved? Because it's my understanding that you and IJ came in at a later point of the case, like you weren't there from the very beginning necessarily.
Yeah, well, just to talk about our starting point, it was November 2nd, 2017, when the Indiana Supreme Court's decision came down. My colleague Sam Gedge and I have a case challenging an Indiana state court. It's actually now pending before the Indiana Supreme Court, challenging their use of forfeiture funds. The state constitution commands, I'm sorry for this aside, but I think it's interesting. The state constitution commands that 100% of forfeiture money go to a school fund. And instead, since at least the early 80s, Indianapolis and several other counties and cities have been collecting all of that money for themselves. They use it to fund prosecutors and the police force. And it's created this perverse incentive to sort of pursue property on the streets and take it away from people. So anyways, Sam and I have that challenge up before the Indiana Supreme Court, and our local council back in November 2017 sent us the Timbs decision and said, hey, this is also about forfeiture, and it's from the court that we're litigating in. Okay. Well, we were talking about cert-worthiness, and this case checked a lot of boxes immediately upon reading the Indiana Supreme Court's decision. But I think it's important to appreciate that we still needed a willing client, and Tyson was enthusiastic about taking this thing all the way to the end. He was confident in his argument, which was that this was unjust, and thankfully he was confident in the Institute for Justice to take his case on. And he's been a tremendous wind in our sails, if you will, from the beginning. He's an inspiring guy, and he's very humble. And he says, I could never do what you guys do and stand up in court and make those kinds of arguments, but I know you're the right guys to do it for me. And, you can't buy a client like that. You're not going to get a client like that if what's at stake is money, the institutional interests. So, I feel really blessed. I feel blessed to have gotten into the legal profession in the first instance. I was lucky to get directed towards IJ. And I've got lots of other examples of fantastic clients who were inspired to fight for something. And we come along and, we're fortunate to be able to provide it to them for free. And that changes the economics of it, to be blunt. And it gives people, it's really just a question, do you want to fight or not? It's not a question of, can you afford to take a case to the Supreme Court or not? I think if you paid Sam and me to put together that brief at standard firm rates, we would have easily bankrupted Tyson. It would have just been an impossibility. We probably would have bankrupted some small companies. I mean, it's probably like $500,000 or more worth of legal work.
Yeah. No, it's amazing that, the expense alone would, in the absence of organizations like Institute for Justice and other civil rights organizations, really prevent a lot of these cases effectively from coming before the Supreme Court or any court really at all in a lot of cases. One thing that I thought was really interesting about your briefing in this case was how historical it was. I mean, it's not every day that you see a Supreme Court brief referencing, Magna Carta and the English Bill of Rights and the Star Chamber in a non sort of hyperbolic way. And I was wondering about the decision to kind of take that historical focus, which was reflected in some of the amicus briefs as well, and, why you felt like that was the right way to go in the briefing.
Well, I found it a bit boring, honestly, all of this English law. And there's a tremendous story to tell, but it always feels familiar, right? And I think that it can come off to a sophisticated legal audience as cherry picking the best history that you can find, essentially weaving together quotes. But here, our focus on history was really dictated by the legal standard. In the McDonald versus City of Chicago case in 2010, when the court incorporated the Second Amendment right to keep and bear arms, they laid out what the standard for incorporating a federal constitutional protection against the states is going to be. And they did that by weaving together all of the incorporation cases, and I think correctly concluding that their focus is on history, and that to be an incorporated right, you have to be deeply rooted in our nation's history and traditions, and the right has to be fundamental to our scheme of ordered liberty. I mean, in some sense, that those are just kind of magic words that say this right has to be a right that can be demonstrated to have been important to our country over time. And I think the key historical moments for us were 1791, when the Bill of Rights was adopted and the excessive fines clause was adopted. But of course, that moment was the result of literally hundreds of years of English constitutionalism. And the excessive fines clause, the Eighth Amendment as a whole, draws directly from the English Bill of Rights of 1689. And the court itself in McDonald reached to these same sources to hold that the right to keep and bear arms met this standard. And so really, we had no choice but to focus on history.
Right. No, that makes a lot of sense. And one thing that a lot of people have commented on is sort of the relationship between the due process and privileges and immunities arguments, and how those sort of were presented differently, perhaps, by the relevant parties in the McDonald Second Amendment case and in this case. And I was wondering if you could just say something really briefly about sort of the difference between the two, and why you took the approach that you did.
Well, I mean, I think it can be summed up by, again, looking to the most recent incorporation case, McDonald. As some people know, Justice Thomas in that case took a different approach than the four-justice plurality led by Justice Alito. He was the critical fifth vote to hold that Chicago and other state and local authorities have to comply with the Second Amendment. And his view was that that right is incorporated not through the 14th Amendment's due process clause, but by its adjacent privileges or immunities clause. Now, this is distinct from Article 4's privileges and immunities, but we don't need to get into that at all. Effectively, we had to make that argument to get Justice Thomas's vote. And the backstory from McDonald was that Alan Gura and Clark Neely, who litigated the DC versus Heller case that established you had a federal right in the District of Columbia, that is, to keep and bear arms, then brought the follow-up case trying to establish that it also applied to cities like Chicago. And Alan, notably led his argument with the Privileges or Immunities Clause, emphasizing that it was the correct textual and historical basis for incorporating Bill of Rights protections. And that turned out, whether intentionally or not, to really inspire Justice Thomas to lay down a marker and say, I agree, that's the only defensible way to incorporate rights. In our case, Brian, it comes down to, do you want to get Justice Thomas's vote, or do you want to forfeit it? And so despite, we didn't make a lot of it, but the last, I think, 3 to 4 pages of our brief says, hey, in the alternative, if you think that's the correct method, it's also incorporated under the Privileges or Immunities Clause.
Yeah. So what were you expecting from the respondents from the state of Indiana in terms of their arguments? And were there any surprises? Were there any surprises for you there in terms of the briefing?
I was surprised how good it was. Their so-called red brief, their response on the merits, they didn't have a lot to work with. As I said, the right had an obvious and long-standing importance in Anglo-American law. It was easy to demonstrate that. On top of that, the Supreme Court on 5 occasions, rather recently, like just within the last generation, has observed that the excessive fines clause should be understood to apply to the states. It just had never formally held that. And so while we were kind of playing a sort of game of defense, just saying like, well, here's the standard, we meet the standard, please just hold officially that this is incorporated, it was a much heavier lift for the lawyers for the state of Indiana. And what struck me most about their red brief was how good it was. They managed to make some lemonade out of lemons and make a fairly compelling argument on the history that whatever you might think of the excessive fines protection, it just doesn't apply to forfeitures.
This sort of in rem,
I think that's right.
Yeah, the in rem argument that they were making.
Yeah, what they would call the fiction of civil forfeiture actions, which it's true, have historically at times been understood to kind of be a constitution-free zone where the government could just strip people of their property without the conventional protections of criminal law, which you would expect even from just watching a police drama on TV. The right against self-incrimination doesn't necessarily apply. The right to a prompt post-seizure hearing doesn't necessarily apply, even though you're entitled. Like if they take a ship from you in a port and you don't get notice of the proceeding, the government could still take the ship. So it's long been understood to be a constitution-free zone. Now the important rejoinder to that is that our Constitution also used to allow slavery, and we also used to understand cruel and unusual punishment to not be implicated by putting someone to death on the wheel, or hanging, or any number of other what today might be regarded as outrageous punishments. The point is that these were meant to be societal standards. They were meant to use a perhaps controversial word, evolve with the times. And certainly there are many other cases that did apply the excessive fines clause to even civil in rem forfeitures. Most importantly, there's this case Austin versus United States, decided by the U.S. Supreme Court in 1993. And Austin said, look, under federal law, a civil forfeiture, it's really a label. This is what matters is the government trying to punish someone? And if they are, then the excessive fines clause applies, as it did in that case. And so, Indiana was forced to argue that while that might be true under federal law, it's not true under state law. So here's another dimension of sort of I think, incorrect federalism, this view that states only have to do what has clearly been laid down by the Supreme Court as a boundary. That can't be right. I mean, state judges, just like federal judges, take an oath to defend the Constitution of the United States and to protect people's rights under that document. I think it's approaching the case backwards to ask, have we been commanded to comply with the Constitution? Mm-hmm. Courts should affirmatively try to protect people's rights.
Mm-hmm. Yeah, that doesn't sound so unreasonable. So coming into the case, it does seem like, given the framing from the Indiana Supreme Court, the fact that the Supreme Court took the case in the first place on the incorporation issue, it does seem like it was sort of some signal that they were looking to reverse the Indiana Supreme Court on that issue, at least. Were there any surprises for you in the oral argument, kind of signaling what the justices were thinking or where they might kind of go in actually deciding the case? I mean, one thing that kind of struck me was the way in which so much of the conversation seemed to almost assume incorporation, and the justices wanted to talk about sort of application under the particular circumstances.
I think that's my assessment of what was going on in the argument at bottom. That we expected that, because ask yourself, what is the constituency from the court for holding that the excessive fines clause doesn't apply to the states? How do you count to 5 for that, where Indiana wins and we lose? I think most observers of the case felt like the challenge, as you were suggesting, was getting cert. If we could get the court's attention, get cert granted, we would win in a walk. It was just a question of, is it a 6-3 ruling or is it a 9-0 ruling in your favor? Because you can assume that the liberal wing of the so-called liberal wing of the court, I'm thinking of Justices Ginsburg, Sotomayor, Breyer, and Kagan, those 4 justices, jurisprudentially, if you will, their sort of legal view assumes rights. I think would agree with Tyson that Indiana had an obligation to protect against excessive fines, regardless of their views of what may or may not be excessive. They're going to believe as a starting point that states have to comply with that federal protection. And so the focus turns to, you just need one other justice to win at a bare sort of 5-4. And Justice Alito had written the opinion in McDonald in 2010 with 4 other justices, laying out exactly what he wanted to see in order to incorporate a right against the states. And again, that's why we had a sort of playbook given to us that we had to implement with the historical analysis. So our case was largely pitched to Justice Alito. To be kind of crass about it, but there is a lot of this nose counting that goes on in trying to win a Supreme Court case. And to Justice Thomas, as I said before, we wanted to give him the opportunity to write a concurrence that would reverse the Indiana Supreme Court's judgment, regardless of what the rest of the court did. Mm-hmm. Of course, the big question marks for us were the new justices. Where is Justice Gorsuch? Where does Justice Kavanaugh stand on this?
Yeah, it doesn't seem like that's too much of a question after the argument anymore, is it?
Precisely. I was very satisfied, that they sort of seemed to be smiling throughout my presentation and didn't have any hard questions for me. But then they just, it's fair to say, lit into Tom Fisher, who's a very capable lawyer, and as I was saying, made, I think, the best argument he could with what he had. But Justice Gorsuch and Justice Kavanaugh seemed to be saying, well, Gorsuch literally did say, come on, we're really arguing about this in 2018.
Yeah. Do you think that signals, I mean, it's a little bit of a digression, but I mean, do you think that signals anything about the way that they might be thinking about some of those Bill of Rights provisions that, for historical reasons haven't actually been incorporated? Because I mean, they almost signaled, it seemed like to us in a sense that like they didn't think that that was right.
I think it's true that they were surprised that anyone was taking the position that the excessive fines clause doesn't apply to the states. What's really interesting is how far does that go in their jurisprudence? And, at this stage, we just don't know. Lower court judges don't make rulings about incorporation on any sort of regular basis. So it's not like either one of them have a track record. This is something you only do when you're on the Supreme Court. But they did signal that they're not radical, at least as to the first 8 amendments. I think the really interesting question is, what federal protections do they recognize as against the states outside of those first 8 amendments?
Yeah.
Are they coming on so strong on the theory that the first 8 amendments apply to the states because they think there's lots of other federal rights that don't?
Mm. Yeah. Well, one thing I wanted to ask you about sort of tactically was the Justice Breyer asked a series of questions to the respondent that I thought were really interesting about, when confiscation would be permissible. And I mean, he basically came just out and said, well, basically always would be permissible.
Yeah.
I mean, do you think he had a choice? Would you have answered that question in the same way, or was there some way to finesse it? Because that just seemed like a really tough thing to have to say to the court.
Yeah, it was striking. I think that my litigator Wesley brain immediately goes to the idea, well, maybe, Your Honor, but that's not this case. Here, this vehicle was intimately involved with a crime. Of course, that's not true. He just happened to drive somewhere. And when you live in rural Indiana and are summoned to a parking lot, you tend to drive there. And so his theory did have to be radical, that like, look, we can forfeit basically anything that has any connection loosely defined to a crime. But I don't think it had to be so radical in the oral argument itself. I think he could have said, look, it depends. And that would have been the correct answer. It's not true that the government can forfeit any property it wants, particularly with a focus on the value of the property. He wasn't just saying we can take anything that's connected to a crime. He was saying, look, if we target a guy with a fancy car, the Bugatti was the subject of discussion and argument.
Or the jalopy, the jalopy.
Either one. There are really no boundaries. And historically, one of the animating concerns of the excessive fines clause was that government, this was pointed out by Justice Scalia, in fact, that government is motivated to collect fines and forfeitures from people because, unlike every other form of punishment, it makes money. You can fund your operations by taking property from people, whereas putting them in jail, that's expensive. And indeed, one of the, at least anecdotal, if not empirical, but it's actually empirical, it's something like 80% of federal forfeitures are civil in nature and don't involve any criminal charges, right? They say you committed a crime, but they don't ante up and charge you with a crime. They just take your property.
Yeah. Well, that was one thing that really struck me about the oral argument too, is it seemed like at least some of the justices seemed to want to be creating an analogy or a comparison between forfeiture and fines and sort of criminal punishment. And what was your take on that? I mean, did you have any sense of sort of where that was going, and how did were you anticipating having to respond to those kinds of analogies?
Yes. In light of Indiana's argument that the decision in Austin should not apply to state and local forfeitures, we knew that the justices were going to be curious about whether Austin remains good law. I mean, of course it does. It was a unanimous decision from 1993, and many other states haven't questioned it. But I was surprised that there was a question about whether it could ever be punitive. I'm thinking of Justices Alito and the Chief. Whether it could ever be punitive to take away property that was even loosely connected to a crime, effectively like questioning the fundamental reasoning of Austin. This is why tactically, as you say, I was trying to keep the court focused on what the real issue was. Is just broadly speaking, does the excessive fines clause apply to the states? And it's a battle for another day. I think an important one about how much stuff the government has access to forfeiting when you happen to commit a crime. I don't mean to say that casually. Nothing about our argument prevents the government from imposing serious fines for serious crimes. We weren't arguing that Tyson's vehicle, as a constitutional matter, wasn't subject to forfeiture. We were just saying that, look, under all of the circumstances of the case, it is excessive to take this particular vehicle. And unfortunately, there's no mathematical formula for that. It's not just a question of, the numerator being what the value of the property is and the denominator being like, how much of a criminal fine could be imposed. Although that was literally the test that was applied by the Indiana Court of Appeals here. That's not the test. As the Supreme Court has emphasized in cases like Bajikagian versus United States and in Austin itself, it's really a question of all of the circumstances. The court declined in Austin to articulate factors for when property could and could not be excessive to forfeit. And so that remains to be seen.
Well, so to kind of change the subject a little bit, were there amicus briefs that you found particularly helpful or useful as, one of the litigants in the case? And sort of, if so, what was your sense of what made for a good amicus brief under the circumstances, or a helpful one under the circumstances?
Oh, I think that's a great question. The NAACP's brief really impressed me. They actually were on two briefs. The organization was on one of the briefs on behalf of civil rights groups, both liberal and conservative. But the Legal Defense Fund wrote its own brief, which I thought was very illuminating. They discussed one of the other unincorporated rights that Justice Ginsburg mentioned in the argument in the Timbs case. That is the right to be convicted by a unanimous jury. The court held in Apodaca versus Oregon that indeed that Sixth Amendment right, although it applies in federal court, doesn't apply in state courts. And there's only two states, Oregon and Louisiana, that when we were writing our briefing had that kind of process for convicting people where, I think in both states it's 10 jurors can vote to convict and 2 can vote to acquit, and you still get a conviction. The NAACP brief laid out that, look, as a historical matter, and again, that's the test for incorporation, these laws were, in the case of Louisiana, inspired by racial animus against Blacks. And in Oregon, it was animus against Eastern Europeans, specifically Jews. As the result, in Oregon, it's kind of interesting, as a result of this sensationalist trial. I'm learning all of this from a sensationalist trial in which 2 Jewish jurors refused to convict a Jewish defendant, which set off a firestorm of suspicion of Eastern Europeans broadly. and their ability to, in the view of proponents for changing the rule, their ability to sort of follow the rules in America. And, so the NAACP is saying, look, the history of these allowances is racial and religious animus. The court shouldn't allow states to escape federal constitutional rights based on that. And I think that's correct. Indeed, in this last election, this past November, Louisiana voters passed a constitutional amendment to change that and require unanimous jury convictions in their state. So now it's just Oregon hanging out there. Who knows what the court would decide if that came back before it today. For what it's worth, Apodaca is really the result of a one justice concurrence. It's just because Justice White thought that Oregon could do that Oregon got to do that.
Yeah. Well, there were some amicus briefs submitted by law professors in the case as well. And I was wondering if you could opine on those to some degree. I mean, do you think they were helpful to you or to the court? And if so, what made them helpful? In other words, like, if law professors are going to engage in amicus briefing, whether at the Supreme Court or elsewhere, I mean, from your perspective, what can we do to be most effective?
Yeah, I'd forgotten about that dimension of your question, but it's what I really liked the first time around. Specifically in our case, I thought the brief of the Eighth Amendment scholars, Beth Colgan, who I mentioned before, Nicholas McLean, and a few others. I mean, these folks were really the experts on the history of the excessive fines clause and what it was meant to do, back in 1221 with Magna Carta. And by the way, one of the sort of nervousness is one of the things I was really nervous about in writing the brief and bringing the argument to the chief was that I had heard him say several years ago that we hate it when people quote Magna Carta. We like our authority more recent than that. But it was true that there was a lot of history here. It's a lot to bite off in a brief. And, we wanted to keep things simple, to emphasize to the court that the solution here was obvious. Just hold that the excessive fines clause applies to the states. So it's just a huge release of pressure from us to have law professors who were ready, able, and willing to sort of use their existing scholarship and transform it into advocacy on behalf of an important right. I mean, Nicholas McLean put together, I thought, a tremendous brief that walked through why today there's just as much of a need for excessive fines protection as there was at Runnymede when, famously the barons insisted that the king stop stealing their land and property.
So, like, really.
So, I mean, yeah, I mean, to put it in concrete terms, I think law professors should look at what they already have on hand when they're asked to do an amicus brief and transform it into something different. That is, like, you've got the research. In our case, they have the history. But an amicus brief is a different application of that research than laying it out in neutral terms in a law review article. And an amicus brief is an opportunity to put on a slightly different hat, that of an advocate, and you don't have to walk that neutral line quite as much. I think the best briefs do two things. They add something new to the case, rather than just writing a so-called Me Too brief. You say something that no one else is saying. The NAACP is an example of that. There were, of course, several historic, history-focused amicus briefs in our case. But Nick McLean's was particularly good because he seemed to be communicating to the court that it would be making a profound historical digression, an accident, if you will, an offense to the history of the excessive fines clause to hold that states didn't have to comply with it. And I think that some professors submit briefs that are sort of focused more on a Platonic view of the law, or like what the Supreme Court should adopt, starting from tabula rasa, where there were no previous decisions. And the best briefs, I think, recognize that the court has to write an opinion that's based on precedents, and they just walk the court through why the solution is obvious, not hard.
So Wesley, I was wondering if you could talk a little bit about what, if anything, you learned from your first time arguing a case before the Supreme Court, and what, if anything, you would do differently, or kind of a new perspective you might bring next time you argue before the Supreme Court.
Well, I like how you're thinking. It's a lot of fun. It's an opportunity to speak to these people who, of course, I don't know, but you sort of feel like you know them if you read a lot of Supreme Court opinions and think and talk a lot about where things might go. We all like to pretend like we can predict what they're going to do, but believe me, I'm often wrong. So it's a great thrill to actually be in front of them and have an opportunity just to talk to them, regardless of what it is we're talking about. I think that the thing that I learned most is that the court has a job to do, and the lawyers have a job to do, and the best advocates have this rapport with the court where it's almost like they're a peer, a very respectful, deferential, patient peer, but a person of equal intellectual standing who has the solution that the justices ought to follow based on all of the circumstances of the case. And it's not like in the past I've thought I will be a helpful law clerk to the court. And that suggests, as I was suggesting with some scholars' briefs, a sort of neutrality. I'm just here to provide the court with information. I think what the best advocates do is show up with a firm conviction that, the court really should listen to them and not the other guy. And if I were to go back, which I hope to do, but of course it's not guaranteed at all. I was lucky to get to be the spokesperson for a talented team of lawyers this time. I don't know if I'm going to get that chance again. But if I do, I think I'll go back in with a lot more confidence, not just for having done it before, but because that confidence wins. You of course, have to have a mastery of the material. There's no getting around that at any level. But it is on a different level in terms of what could come up. At times during preparation, I would say to the team, like, we have to be ready to defend the entire Constitution. The court's going to have questions about the Sixth Amendment right to a unanimous jury verdict, as they did. The court's going to have questions about the grand jury indictment right, which the court held long ago doesn't apply to the states. And we have to read up on all of that stuff. It's a lot of like trying to anticipate what they're realistically going to ask, but preparing even for this very marginal risk of what they might ask. In the end, the argument went much as we anticipated, and the only thing that really felt like a curveball was Justice Breyer's line of questioning to me, from which Justice Ginsburg saved me. That I think is a place that even the best Supreme Court advocates have found themselves in.
Yeah, for sure. So Wesley, it's been really great talking to you about the case and about your experiences. And I know it's dangerous, but I feel like I can't wrap up an interview like this without at least asking you if you have any guesses about what you think might might happen? And in particular, like not just the outcome, but sort of like, how do you think the court's likely to get there? And what do you think it might do in this case?
Well, I think the most straightforward application of McDonald suggests that Justice Thomas votes to reverse on the theory that the original public meaning of the 14th Amendment included incorporation of the first 8 amendments, including the excessive fines clause. What's interesting about that position, although it has some other downsides, it has the virtue of incorporating rights that today aren't incorporated, like the unanimous jury verdict, the right to indictment by grand jury, incidentally, the right to a civil jury trial in cases involving $21 or more. That could potentially make a small claims court unconstitutional.
Oh my.
But that sort of absolutist view, I think he is absolutely going to adopt. I say absolutely, but I feel very confident that he'll write that concurrence. And I think Justice Alito is, if you'll allow the expression, kind of boxed in by his McDonald opinion and our straightforward application of that reasoning. Certainly Justices Gorsuch and Kavanaugh and Sotomayor all suggested that they feel strongly that the excessive fines clause should apply to the states. Now all we have to ask ourselves about whether or not we're going to win is, do Justices Ginsburg and Breyer believe that states should be free to impose constitutionally excessive fines? That seems like a no-brainer. The answer is no. And so the only questions that I have are about the chief. And he did, to my surprise, really want to talk about what's next on the horizon. He did seem, as you said earlier in the interview, to assume that the clause applied, but had very pointed questions about what the court might do in future cases involving the forfeiture of property. And he seemed to signal, as did Justice Alito, a skepticism that this larger project of trying to make it unconstitutional for the government to strip people of their money, their home, their truck, that the court's really going to want to get into that. It's good to be in a position where you're only asking questions about one justice, maybe two. Because that means you're going to win. And what I would really like to see, what I'm hoping for, is an 8-1 decision in which 8 justices agree based on a straightforward application of the due process incorporation standard that the excessive fines clause applies to the states, with that one justice concurrence from Thomas saying that that's also true under the privileges or immunities clause.
Yeah, I don't know. Honestly, I'm kind of inclined to put my money on that as well. And it seems like this story of the excessive fines clause is only beginning. So I'm really interested to see where it goes next.
Oh, there's active litigation, not just in the area of excessive forfeitures, but also in the area of fines and fees. I mean, our brief discusses situations where Midwestern towns really use their populations to harvest fines and fees to fund the city. Instead of raising taxes, they just take people's money for having grass that's too long, or in some cases like broken screens. So I do think that there's a future for this clause, and hopefully courts will take it up as an important issue.
Awesome. Well, Wesley, thanks so much. It's been really great talking to you.
Yeah, Brian, it's always nice to hear your voice. Thanks for your interest in this case.
Amendment 8.
Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
The purpose for setting bail is to assure the presence of the defendant at his trial. What is excessive bail, therefore, depends upon the facts in each particular case. In a few instances, as when a capital offense such as murder is charged, bail may be denied altogether. Whether fines or penalties are cruel or unusual must also be determined on the fact torture is one form of punishment that would be deemed cruel. Cruelty under this provision must be tested not in the abstract, but by weighing both the end and the means used. The Supreme Court has, for example, declared that for a state to imprison a person whose only offense is that he is afflicted with a disease constitutes cruel and unusual punishment, contrary to the Due Process Clause of the 14th Amendment.